Hey everybody, it's attorney Veronica McClendon. You know how they say never forget where you come from? Well, I won't say that I forgot where I've come from, but sometimes it's easy for me to forget what it's like to not be a lawyer who does estate planning every day, all day. And so when I was talking to some clients yesterday, it came to my attention that the stuff that I think about all the time, most people are not thinking about at all. It's not something that is part of their everyday thought process. So, with that in mind, it's important that people like me who are lawyers are very intentional about remembering where we were before we learned everything that we learned so that we can explain to our clients from that perspective and not from the perspective of someone who's been doing this work for so long. So, the example that I am thinking about when I went to law school, I didn't know anything about wills, trust, probate, heirs property. I really hadn't heard anything about it at all. The most that I knew about wills and estate planning was learning about my family property in Louisiana. Remember learning from my mom that when her mother's parents died, they had a will and they left my grandmother and her siblings some property. Um, After that, I didn't know anything about it. I didn't understand what was going on, but I that's the only thing I knew about wills before going to law school. I went to law school 3 years, graduated 15 years ago to this year. We actually celebrating our 15-year class reunion soon. Graduated 15 years ago. And when I graduated law school, don't you know, I still didn't know anything about wills, trusts, estate planning, heirs, property, probate, any of the things that I deal with every day today. It took a few years before I even started to take classes on wills and trusts. I didn't take it in law school. I thought it was going to be boring and depressing. So I didn't take estate planning in law school. And by the time I started to get into this field, I realized just how vast it was. I started out doing simple estate plans, simple wills, maybe powers of attorney and healthcare directives, maybe not. It wasn't until a few, like when I started my practice, my law practice pretty much, that I started to learn that there's a lot more to estate planning than wills and trusts. Not than wills and trusts, but than simple wills. I realized that I learned about trusts. I learned about more complex wills and just more advanced estate planning. It's something that I was a lawyer for several years before I even knew anything about this stuff. So now, flash forward 15 years after graduating law school, having been in estate planning and probate work, heirs property work for about 8 or 9 years now. Now I forget that the rest of the world hasn't been doing all the stuff I've been doing for the past 8 or 9 years. So it's important for me to kind of go back to where I was before and explain why estate planning is so important and what has to happen when someone dies and their estate needs to be administered. So that was a really long introduction to me saying that when you have someone who has died with a will, this is someone who actually went through the process of doing estate planning and they created a will before they died. When you actually have that will, that person has died, first of all, you have to take it to probate court to have it probated. If a person died with the will, they did not have any kind of trust planning in place, you're going to have to take that will to probate court in order to first have the will validated by the court. The court has to make sure that all of the legal requirements have been met so that it is a valid will and that it is eligible to be probated through the probate court. Once the court makes that determination, then they're going to what do we call it? They're going to appoint the executor of the estate or the personal representative. This is usually going to be the person who's named in the will. They're going to appoint that person to represent the estate. Once that happens, that person has the full authority to manage the estate. This means that they can they can access bank accounts and other accounts on behalf of the deceased person. They can inquire about things related to their personal affairs so that they can get an understanding of everything that that person left when they died. And they also have the legal authority to sign over the property from the estate to the people who are named in the will as beneficiaries of the estate. A lot of times people go, they have the will, they take it to probate court. So, first of all, I'm going to say a lot of people don't realize that you actually have to take the will to probate court. Probate court is not avoidable when a person died with a will. That's the way it's designed. So once the probate court authenticates the will, says that it's a valid will, and they appoint the representative over the estate, that personal representative has some work to do. Their job is not done once that will is probated. What they're going to receive, and let me be clear, this is for the state of Georgia. The words and terminology could be different. The process could be different in other states. But in the state of Georgia, the probate court is going to provide the personal representative with letters testamentary. Those letters testamentary give that person the authority to act on behalf of the estate and carry out the terms of the deceased person's last will and testament. So once they get that authority to carry out the person's wishes in their will, they actually have to take steps to make sure it happens. So that means if there is real estate in the estate, the personal representative is required to, well, they should sign deeds to say, I'm the person, as the personal representative of this estate, I am transferring ownership of the property to the people named in the will as beneficiaries. They need to go to any bank accounts that the deceased person owned, get the money out. Many times they're going to need to put it into an estate bank account, pay any bills that are needing to be paid out of that estate bank account, and then distribute the remaining money to the people named as beneficiaries in the will. There might be changing things over from I don't know, I'm trying to think of other things that may come about. Anything that needs a change in ownership or a title change, vehicles, in order to change the ownership of a vehicle from the deceased person to the person named as a will in the will as a beneficiary. All of those things are going to require actions from the personal representative to make it happen. This is not something that, one, is common knowledge, and two, that even attorneys will encourage their clients to take care of. I'm not sure if it's something that's more so of like things of a bygone age, or maybe the attorney explained that what their representation entailed and the client didn't realize that actually transferring ownership of the property was not included in that. But I found that there are a lot of attorneys even who will probate a person's estate, have the personal representative appointed by the court, but they don't assist the personal representative with transferring the assets from the estate to the beneficiaries. And again, I don't think there's any wrongdoing in that. I don't know what's going on, what's the backstory, but I've seen it happen many times where someone hired a lawyer to help them probate their loved one's estate. They became the executor or the personal representative. And then from there, the lawyer said, thank you so much for hiring us. We're done here. Have a great day. And in some cases, many years, even decades have passed, and the personal representative or the executor still is the one who has control over the property based on that will being probated. But they haven't taken any legal actions to change the ownership from the estate to the beneficiaries. And this can cause problems later on down the line, especially when there's multiple beneficiaries to a particular property. So, for example, someone might say, I give all of my property, both real and personal property. These are common. This is common language in especially older wills. I give all my property, both real and personal, to my three children, Jack, Jane, and John. So they give those three children this property in the will, and it doesn't say Jack gets my house and Jane gets my car and John gets my real property and Jane gets my bank accounts. Like, it doesn't say those specific things. It just says all of my property goes to all three of my children. So that's the first issue, is that we don't know who gets what. And so according to those terms, everybody shares everything equally, which, as you can imagine, can cause problems. We got the three over here on the house, three over here on the rental property, three over here on the bank accounts. And bank accounts are easy. You can split money three ways, but splitting a house a rental property, that makes things a little bit more complex for the family. But that is how a lot of the older wills have been written, and so steps have to be taken to make sure that we see clearly that the parent is deceased now, and now that property has been changed over to the children. The only way to do that is with some kind of a filing in the real estate records. Usually it's going to be in the form of a deed. So the personal representative might write a deed of assent, and then they would say the real estate that was in this estate is now owned by the children that were named in the will. What I like to see is when people write their wills, so they say this house goes to Jack, this house goes to Jane, this bank account goes to John, so that it's not all mixed together. And even if somebody has done that in the will and said, 123 Happy Place goes to Jack, well, we need to still have the personal representative to sign a deed from the estate of the parent to Jack as the beneficiary. If that doesn't happen, there's nothing in the real estate records to show that ownership changed from the parent to a specific child. So going back to what I was saying earlier about the issues that can happen when a will was probated decades ago and many years have passed, and now the state still owns the property still looks like it's in the parent's name. Some of those beneficiaries may have now died or become incapacitated. They may no longer be able to handle their own affairs. So now the executor not only has to change ownership from the deceased person who wrote the will to their beneficiaries, but they also might have to get somebody to probate estates of the beneficiaries so that it goes from the beneficiaries to the children of the beneficiary, or whoever it is inheriting from that beneficiary. And I've had to do this a lot where it looks like the person did everything they're supposed to do. The person who owned the property, they created a will before they died. When they died, their person named in the will as the executor or the personal representative, they took the will to probate court. They had the estate probated. But that key piece of signing the deed to change the ownership from the deceased person's name to the name of the beneficiary, that step was not taken. So it looks like to anybody looking at the title to the property that the deceased person still owns it. And so we really have to make sure that people know that probating the will is the first step, but it's not the only step. From there, it's very important that the personal representative to the estate actually do take steps to transfer ownership from the deceased person's name to the beneficiaries named in the will. So that's all I'm going to say about that today. I thought it was so important to mention this because I think that this key step is often left out when it comes to estate administration, when it comes to probating a will. So I want to make sure y'all don't make that same mistake. Thank y'all for tuning in. Again, this is attorney Veronica McClendon, and I will be back with more information that you need to know about wills, estate planning, probate, and heirs property. Y'all take care.